Hello and very warm welcome once again to the Tax Express. The Tax Express brings to you latest updates and case law analysis on regular basis in GST and income tax. And today we are going to discuss yet another important judgment delivered by the Honorable Kolkata High Court in the matter of Suncraft Energy Private Limited on 2nd August 2023. This is a significant judgment from the point of view of taxpayers on the issue whether department is justified in insisting the taxpayer to reverse the ITC not reflecting in GSTR 2A for the financial year 17-18 and that too with interest. We know that this has been a contentious issue for long and department has been sending scrutiny and show cause notices in respect of ITC taken in excess of that reflecting in 2A. The CBIC later came up with circular number 183 to provide guidelines as to the manner in which such disputes may be handled by the department and allowing the taxpayer to submit copies of invoices along with certificates from their vendors wherever applicable in respect of invoices not reflecting in 2A. In this case, the case of the petitioner was that department has issued notices for reversal of ITC with interest on the basis of certain invoices not getting reflected in GSTR 2A. Thereafter, the department issued demand order for payment of ITC claimed in excess of GSTR 2A together with interest. Aggrieved by the said order, the taxpayer filed a writ petition before the Honorable High Court. The petitioner contended that they have replied to the show cause notice along with copies of all invoices in possession and payment details. He further contended that he has complied with all conditions of Section 16, paid tax to the seller and therefore is entitled to claim ITC. The Honorable High Court heard the rival arguments on both sides and also referred to Supreme Court judgment in the case of Bharti Airtel, wherein it was held by the Honorable Supreme Court that GSTR 2A is only a facilitator to determine the correct tax liability of the taxpayer on self-assessment basis. The court also took note of the Delhi High Court judgment in the case of Arise India Limited, wherein it was laid down that instead of resorting to proceed directly against the recipient of the genuine ITC, the department must first initiate proceedings against the defaulting supplier. The court in its judgment held that there is no automatic reversal of ITC by the recipient on the basis of certain invoices not getting reflected for fault of the supplier. The department must proceed to take action against the erring supplier first before asking the recipient to reverse the same. The department cannot be said to be justified in proceeding against the recipient directly unless an exceptional case is brought out by them for collusion between the buyer and the seller missing, closure of business by the seller, etc. Therefore, the Honorable High Court ruled in favor of the appellant and set aside the demand order issued by the department. We have been kept saying that GSTR 2A is not a valid criterion for denial of ITC in the hands of the recipient for the financial year 17-18 and it was only in the nature of facilitation as held by the Supreme Court as well. Now this has been affirmed by the Honorable Kolkata High Court in this judgment and rightly so. The court delivered a very important judgment and considered the judgments in Bharti Airtel and Arise India in right earnest. It may be noted that CBIC has come up with circular number 183 for the financial year 17-18 and 18-19, which allows the taxpayer an opportunity to submit copies of invoices and relevant certificates as per the said circular in cases where proceedings are pending for alleged difference between ITC claimed in 3B and 2A. But it is settled principle of law that circulars are binding on the department but not on the taxpayer. The taxpayer may, however, take the benefit of the circular if it is otherwise provides any relief to him. The department in such a case cannot deny the benefit of circular to the taxpayer. So this is the latest update on a judgment delivered by the Kolkata High Court in GST. Hope you like the video. Please share, subscribe the channel and hit the bell icons. Thank you very much.